Hello and welcome to the Minimum Competence episode for Wednesday, August 20th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, California's redistricting fight, Musk's NLRB win, Nevada's business court plan, and a legal test of Elon Musk's Twitter stake disclosure defense. Let's remember, you can know the name of a bird in all the languages of the world, but when you're finished, you'll know absolutely nothing whatever about the bird. And read today's legal news. On this day in legal history, August 20th, 1964, President Lyndon B. Johnson signed the Economic Opportunity Act into law, marking a major legal milestone in the federal government's efforts to address systemic poverty. The act authorized $1 billion to fund a wide range of social programs aimed at improving education, employment, and economic security for low-income Americans. It was the legislative backbone of Johnson's war on poverty and a cornerstone of his broader Great Society agenda. The law created the Office of Economic Opportunity, or OEO, to oversee a suite of initiatives, including Job Corps, Head Start, and Volunteers in Service to America, or VISTA. These programs sought to address poverty through direct services, job training, and community empowerment rather than traditional welfare. Legally, the act reflected a dramatic expansion of federal authority in the realm of economic and social rights, shifting the understanding of poverty from a local issue to a national legal and policy concern. It encouraged the formation of community action agencies, or CAAs, which brought poor communities into the policymaking process, a novel approach for federal law at the time. Critics challenged the constitutionality and effectiveness of these programs, with some arguing the act encroached on states' rights and created administrative overreach. Nonetheless, the Economic Opportunity Act became a model for future federal social legislation. By institutionalizing anti-poverty efforts through law, the act marked a turning point in American legal and political history. While many of its original provisions have since been revised or repealed, its legacy continues in modern public assistance and education programs. California Republican lawmakers have filed an emergency lawsuit with the state Supreme Court to block Governor Gavin Newsom's redistricting proposal, which would create 5 new Democratic congressional districts. The GOP legislators argue that the state constitution requires a 30-day review period for new legislation and that Democrats cannot legally move forward with the plan until September 18th, unless both legislative chambers approve it by a 3/4 vote. The lawsuit seeks either a ruling on the merits by Wednesday or a temporary halt to the legislative process. Newsom's proposal is intended as a direct response to a controversial redistricting initiative in Texas, championed by Governor Greg Abbott and supported by President Donald Trump, which is expected to yield 5 new Republican congressional seats. With the GOP holding a narrow 219-212 majority in the U.S. House, the outcome of these redistricting efforts could have significant national political implications ahead of the 2026 midterms. California Democrats aim to pass the redistricting bills by August 22nd in order to place the revised maps on a special November ballot. They justify bypassing the state's independent redistricting process established by voters in 2008 as a necessary emergency countermeasure to what they describe as partisan manipulation in Texas. That state's plan, criticized for potentially disenfranchising minority voters, led to a dramatic walkout by Texas House Democrats. Upon their return, Republican leaders imposed restrictions requiring lawmakers to remain under state police escort during sessions, sparking further protest. A federal appeals court has sided with Elon Musk's SpaceX and 2 other companies, ruling that the structure of the National Labor Relations Board, or NLRB, is likely unconstitutional. The 5th U.S. Circuit Court of Appeals found that laws protecting NLRB board members and administrative judges from being removed at will by the president likely violate the Constitution's separation of powers. The court said these protections improperly restrict the president's authority over the executive branch. This decision is the first from a federal appeals court to challenge the NLRB structure on these grounds, setting a precedent as similar lawsuits are pending. The ruling blocks the NLRB from continuing enforcement actions against SpaceX, Energy Transfer, and Aunt Bertha while the company's constitutional challenges proceed. Circuit Judge Don Willett, writing for the panel, stated that the companies should not have to choose between following NLRB procedures and asserting their own constitutional rights. The NLRB, an independent agency created by Congress, handles private sector labor disputes, and its structure was designed to insulate it from political influence. However, this independence is now under scrutiny. The issue gained momentum after President Trump fired Democratic board member Gwynne Wilcox in January, a move that left the board without a quorum and marked the first time a sitting board member had been removed by a president. Musk, once an advisor to Trump, has a separate pending lawsuit against the NLRB related to another dispute. The court's panel consisted entirely of Republican-appointed judges. Nevada's Chief Justice Douglas Herndon is spearheading an initiative to establish a dedicated business court in the state, aiming to attract companies seeking an alternative to Delaware's Chancery Court. During a public hearing in Las Vegas, Herndon urged the state Supreme Court to approve a commission to draft rules for the new tribunal, which could begin hearing cases as early as 2026. The court would feature judges appointed by the Chief Justice to 4-year terms from a vetted list with input from legal, governmental, and business stakeholders. Currently, Nevada handles business cases through district courts in Las Vegas and Reno, where judges balance other civil and criminal matters. Herndon said the creation of a specialized court would streamline corporate litigation and provide data to inform future legislative reforms. While a constitutional amendment to establish a fully independent business court is underway, that process will take years. The commission's work would serve as an interim step. This move follows a broader trend of states competing for corporate incorporations. Nevada and Texas are positioning themselves as more business-friendly venues, especially for big tech and firms led by controlling shareholders. Companies like Andreessen Horowitz and AMC Networks have already opted to leave Delaware in favor of Nevada. Recent changes in Nevada law now allow companies to waive jury trials via their articles of incorporation, aligning the state more closely with Delaware's procedures. Delaware, while still the leading venue for corporate law, has faced criticism over judicial bias and repetitive judge assignments. In response, it has revised statutes and begun implementing judge rotation. Texas, meanwhile, launched its business court last year and issued its first final judgment in June. Judges there serve 2-year terms, and juries are allowed in some cases. Investors suing Elon Musk over his delayed disclosure of a large Twitter stake in early 2022 are challenging his attempt to use an advice of counsel defense while withholding related legal documents. The plaintiffs, led by an Oklahoma firefighters pension fund, argue Musk is employing a sword and shield tactic, invoking legal advice to justify his actions while citing attorney-client privilege to avoid releasing relevant evidence. They've asked a federal judge in Manhattan to force Musk to formally declare whether he intends to rely on legal counsel or a good faith defense before he testifies in late August and early September. If Musk invokes this defense, plaintiffs will want access to communications with lawyers from Quinn Emanuel and McDermott, Will, and Emery, both of which advised Musk around the time he disclosed his 9.2% stake in Twitter in April of 2022. The lawsuit alleges Musk defrauded shareholders by delaying disclosure, causing them to sell stock at artificially low prices. Musk has denied wrongdoing, stating he misunderstood SEC disclosure rules and acted in good faith once he realized the mistake. Plaintiffs argue that if Musk refuses to share legal advice-related documents, the court should prevent him from using that defense at trial. A similar civil lawsuit by the SEC over the same issue remains pending. The outcome of this discovery dispute could shape the strength of Musk's defense in both cases. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it's certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter form. We'll see you back here tomorrow, and until then, remember, it's much more interesting to live not knowing than to have answers which might be wrong.